12S, the prosecutor versus Ivica Rajić.
Thank you. Mr. Rajić, can you hear me in a language that you can understand?
Da, čujem vas.
Yes, I can.
Sit down. For the sake of the record, can we have the appearances, please? Prosecution first.
Yes, Your Honor, Madam President, excuse me, Your Honors, Kenneth Scott for the prosecution. I'm joined by Ms. Jose Liu.
Thank you very much. For the defense.
Yes, Your Honors. Doris Costa, attorney at law.
The trial chamber is sitting today to deliver its sentencing judgment in the case of Mr. Ivica Rajić. The case concerns his involvement in October 1993 in the attacks against the village of Stupni Do, which caused the death of approximately 31 civilians and the destruction of a village. The sentencing judgment also concerns the rounding up of more than 250 Muslim men in Varoš town and their subsequent inhuman treatments. What follows is only a summary of the written judgment and does not in any way form part of it. The only authoritative account of the findings of the trial chamber is in the written judgment, which will be available to the parties and the public today at the end of this session. The trial chamber will briefly set out the context and facts of the case before going on to review the factors which it took into consideration in determining the sentence. The contents and facts of the case. Ivica Rajić was born on 5 May 1958 in the village of Jehovac in Bosnia and Herzegovina. From May to at least November 1993, he was the commander of the 2nd Operational Group of the HVO's Central Bosnia Operative Zone, based in Kiseljak. On 29 August 1995, Judge ICTY confirmed the indictment issued against Ivica Rajić. Initially, he was charged with 2 grave breaches of the Geneva Conventions of 1949, wilful killing and destruction of property, and 2 violations of the laws or customs of war, deliberate attack on the civilian population, and wanton destruction of a village. On 5 April 2003, Ivica Rajić was arrested and was subsequently transferred to the detention unit of the tribunal. On 27 June 2003, he appeared before the tribunal and entered a plea of not guilty. On 14 January 2004, the prosecution filed an amended indictment against Ivica Rajić. It charged him with 5 grave breaches of the Geneva Conventions: willful killing, inhuman treatment, unlawful confinement of a civilian, appropriation of property, and extensive destruction not justified by military necessity and carried out unlawfully and wantonly. It also charged him with 5 violations of the laws or customs of war: murder, outrages upon personal dignity, cruel treatment, plunder of private or public property, and wanton destruction of a city or devastation not justified by military necessity. On 29 January 2004, Ivica Rajić pleaded not guilty to all 10 counts of the amended indictment. More than a year and a half later, on 25 October 2005, Ivica Rajić entered into a plea agreement with the prosecution. He agreed to plead guilty to 4 of the 10 charges in the amended indictment: willful killing, inhuman treatment, extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly. All the charges constitute grave breaches of the Geneva Conventions under Article 2 of the Statute of this Tribunal. In exchange for his guilty plea, his complete cooperation with the prosecution, and the fulfillment of all his obligations under the plea agreement, the prosecution agreed to recommend to the trial chamber the imposition of, quote, a single combined sentence in the range of 12 to 15 years, with the accused able to argue for a sentence of the bottom of this range, 12 years, and the prosecution able to argue for a sentence at the top of this range, 15 years. End of quote. At the plea hearing on 26 October 2005, Ivica Rajić pleaded guilty to these 4 counts. The trial chamber accepted the plea after being satisfied that it was voluntary, informed, and unequivocal, and that there was a sufficient base for a conviction. The prosecution and the defense filed their respective sentencing briefs on 15 November and 16 December 2005. On 16 November 2005, the trial chamber issued a decision clarifying that the conviction had been entered on the basis of Article 7.1 of the statute only, thereby excluding any modes of responsibility under Article 7.3 of the statute. The sentencing hearing was held on 7 April 2006. The prosecution and the defense made submissions regarding the factors that they recommended to the trial chamber's attention when determining the sentence. In addition, Ivica Rajić made an oral statement depicting the broader context in which the crimes occurred and apologizing to the victims. What follows is a summary of the facts which form the basis of Ivica Rajić's conviction. The facts are described in the factual basis attached to the plea agreement. On 21 October 1993, following an attack of the Army of Bosnia and Herzegovina in Varish municipality, the deputy head of HVO armed forces ordered Ivica Rajić to seize control with the HVO forces of the situation in Varish town and surrounding area. On the same day, Ivica Rajić left the town of Kiseljak with approximately 200 HVO soldiers. He reached Vares the following day. On 23 October 1993, the head of HVO main staff ordered Ivica Rajić, quote, to sort out the situation in Varish, showing no mercy towards anyone. End of quote. On the same day, Ivica Rajić ordered HVO forces under his command to round up military-aged Muslim men in Varish town and to detain them. As a result, based on Ivica Rajić's order, HVO forces rounded up more than 250 Bosnian Muslim men and detained them in 2 schools, the Ivan Goran Kovačić school and the Vladimir Nazor school. During the process of rounding up these men, the HVO commanders and soldiers entered houses, abused their inhabitants, and robbed them of their valuables. HVO soldiers also beat and abused male Bosnian Muslim detainees. Still on the same day, HVO soldiers under Ivica Rajić's command attacked the village of Stupni Do. They also forced the civilians out of their homes and hiding places, robbed them of their valuables, sexually assaulted Muslim women, and willfully killed at least 37 Bosnian men, women, elderly persons, and children. Among the men, there were approximately 6 combatants. On 23 and 24 October, most of the village was destroyed. The trial chamber will now give an overview of the factors that it took into account in assessing the gravity of the crimes committed in order to determine the sentence to be imposed on Ivica Rajić. It will then briefly discuss the aggravating and mitigating circumstances applicable in the present case. In determining the gravity of the crimes, the trial chamber took into account the scale and brutality of the crimes, the role of Ivica Rajić, as well as the impact of the crimes upon the victims and their families. In relation to the scale and brutality of the crimes, the trial chamber found that the sentence should reflect that the crimes were committed on a large scale, were of a particularly violent nature, and caused severe pain to the victims and their relatives. For example, the trial chamber noted that 2 elderly women, one of whom was invalid, were found burned inside a house, and that 7 members of the same Muslim family, 2 men, 3 women, and 2 children aged 2 and 3 years old, were found burned inside their shelter. However, in determining the gravity of these crimes, the trial chamber also took into account the general context in which they occurred. Indeed, according to the agreed facts between the parties, approximately 35 defenders of the army of Bosnia and Herzegovina, who had dug trenches in and around parts of Stupni Do, were present in the village during the attack. In this regard, the trial chamber rejects the submission of the prosecution, according to which the crimes were serious because they were widely broadcasted and received immediate attention from the UN Security Council. Indeed, the seriousness of a crime is not related to such coverage or attention. Were this the case, the gravity of 2 identical crimes would differ depending on their media coverage or international attention. As for Ivica Rajic's role, he was the commander of the HVO's second operational group in the central Bosnia operative zone based in Kisielac. In this capacity, he played a significant role in ordering HVO soldiers and commanders to attack Stupni Do and to round up more than 250 Muslim men in Vareš town. He did so knowing the substantial likelihood that criminal acts would ensue following his orders. According to the agreed facts between the parties, Ivica Rajić was indeed aware that these soldiers had previously committed serious crimes against Bosnian Muslims, including rape, murder, destruction of property, arbitrary arrest, and physical assault. Lastly, the trial chamber evaluated the seriousness of Ivica Rajic's crimes in the light of their impact on the victims and their effect upon the victims' families. In doing so, the trial chamber examined the evidence submitted by the prosecution and found that the victims and their families suffered severe pain as a direct result of the crimes. It concluded that this factor should therefore be taken into consideration when determining the seriousness of the crimes. Let me now turn to the aggravating and mitigating circumstances. The trial chamber has examined the 4 aggravating circumstances put forward by the prosecution, namely Ivica Rajic's position of authority and as a superior, the impact of his crimes on particularly vulnerable victims, Ivica Rajic's participation in a cover-up, and the fact that he absconded and obstructed justice for almost 8 years. With regard to Ivica Rajic's abuse of position of authority under Article 7.1 of the statute, and his position as a superior under Article 7.3 of the statute, the trial chamber first noted that it was not bound to consider these elements as aggravating factors, pursuant to the Stakic, Momir Nikolic, and Naletelic appeals judgments. Furthermore, in the light of the same jurisprudence, the trial chamber found that in this case, Ivica Rajic's abuse of his position of authority and his position as a superior could not be taken into account as aggravating factors, since these factors had already been taken into account when examining the gravity of the crimes. As to the vulnerability of the victims, the trial chamber considered that certain victims, 5 children and 2 elderly women, one of whom was invalid, were indeed in a situation of special vulnerability during the attack on Stupni 2. The trial chamber therefore found this element to be an aggravating factor. The trial chamber was not, however, convinced by the arguments of the prosecution, according to which absconding from justice and participation in cover-up activities should aggravate the sentence. The prosecution did not prove that these elements were aggravating circumstances pursuant to customary international law or general principles of law. However, the trial chamber accepted that these factors could be taken into account when appraising the weight to be attributed to certain mitigating circumstances, especially when evaluating Ivica Rajić's good character. The trial chamber also reviewed 4 mitigating circumstances submitted by the defense and the prosecution, that is, the guilty plea, Ivica Rajić's remorse, his cooperation with the prosecution, and his personal circumstances. The trial chamber held that Ivica Rajić's guilty plea helped to establish the truth surrounding the crimes committed in Stupni 2 and Vareš. This may contribute to the reconciliation of the peoples in the former Yugoslavia and to the restoration of a lasting peace in the region. Such recognition of responsibility also saved valuable court time and resources. The trial chamber therefore found that Ivica Rajić's guilty plea was indeed a mitigating factor. As to his remorse, the trial chamber, after listening to Ivica Rajić's statement at the hearing, felt that Ivica Rajić's expression of remorse was real and sincere, and must therefore be taken into account in mitigation. In respect of his cooperation, in the light of the assessment made by the prosecution in its brief and during the sentencing hearing, the trial chamber has considered it to be a mitigating factor. In relating to Ivica Rajić's personal circumstances, the trial chamber observed that the defense did not submit any evidence regarding to the fact that he had neither been convicted prior to the events nor driven by racial or religious hatred. The trial chamber also notes that the defense's submission, according to which Ivica Rajić enabled 2,000 Jews to flee Sarajevo, has not been proven. Moreover, the trial chamber considers that when an accused has been convicted of extremely serious crimes, his family circumstances can only have a limited bearing on the sentence to be imposed. Finally, in accordance with the statute and the rules, the trial chamber took account of the general sentencing practice in the courts of the former Yugoslavia. Mr. Rajić, will you please stand? The trial chamber has duly examined the evidence relevant to an adequate determination of the seriousness of the 4 grave breaches of the Geneva Conventions of which you have been found guilty: willful killing, inhuman treatment, extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly. The sentence should reflect the fact that these crimes were committed on a large scale, were of a particularly violent nature, and caused severe pain to the victims and their relatives. The sentence should also reflect the importance of the role you played in these events when, following orders of your own superiors, you planned and ordered the attacks and further ordered the rounding up of Muslim civilians, knowing the substantial likelihood that criminal acts would ensue following your orders. The trial chamber considered that the special vulnerability of certain victims is an aggravating factor. However, the trial chamber found that your position of authority and as a superior were not aggravating factors in this present case, but inherent in the gravity of the crimes. Finally, the trial chamber rejected the prosecution's submissions that the participation in a cover-up and obstructing justice for almost 8 years constituted aggravating factors. Furthermore, the trial chamber gave consideration to a number of mitigating circumstances: your guilty plea before the trial, your remorse and your cooperation with the prosecution. Finally, the trial chamber accorded some additional weight in mitigation of sentence to your personal circumstances. The trial chamber hereby sentences you, Ivica Rajić, to 12 years imprisonment. You are entitled to credit for time spent in detention, namely 1,130 days. You may sit down. The trial chamber stands adjourned.
All rise for your vote.